Equity will not assist a volunteer. Number 3, equity deems as done. Equity deems as done that which ought to be done. Equity deems as done that which ought to be done. Number 4, delay defeats equity. Delay defeats equity. Number 5, equitable remedies. Equitable remedies are granted at the discretion of the court. Equitable remedies are granted at the discretion of the court. Number 6, equity aids the vigilant. Equity aids the vigilant. Number 7, he who comes to equity must come with clean hands. He who comes to equity must come with clean hands. Number 8, equity follows the law. Equity follows the law. Number 9, equity looks to the content rather than the form. Equity looks to the content rather than the form. Number 10, equity imputes an intent. Equity imputes an intent to fulfill an obligation. Equity imputes an intent to fulfill an obligation. Is it number 11 or 12? He who seeks equity must do equity. He who seeks equity must do equity. The next number, equity regards the balance of convenience. Equity regards the balance of convenience. Next subtitle, civil law. Civil law. Civil law may be defined as civil law may be defined as a legal system practiced in continental Europe in countries such as France. Civil law may be defined as a legal system practiced in continental Europe in countries such as France. The French civil law has its origin in the Roman Dutch law, and it is predominantly based on a code of laws known as the Civil Code or the Napoleonic Code, from the name Napoleon. Napoleonic Code. The Civil Code or Napoleonic Code laid down the rights and duties of citizens, the rights and duties of citizens, as well as the laws of property, contract, inheritance, etc. It is thus an adaptation to the needs of the 19th century France. The code has over the years been amended and updated to suit the changing times. The main features of the civil law legal system. The main features of the civil law legal system. In a civil law legal system, In a civil law legal system, the main sources of the law are the codes such as the Civil Code, the Code of Civil Procedure, the Code of Criminal Procedure, the Code of Commerce, the Penal Code, and other statutes. According to the case of Jones versus National Core Board, Jones versus National Core Board, 1957, 1957, two QB, that's Queen's Bench, 2 QB, at page 55, Lord Denning stated that the civil law legal system is the practice of inquisitorial system. So, like to inquire, from the word inquire. So, inquisitorial system. This basically means that in civil law jurisdictions, they place very little emphasis on the doctrines of precedent and equity, unlike in the English common law legal system. unlike in the English common law legal system. Further, in the civil law legal systems, the judges undergo specialized training. The judges undergo specialized training. The civil law legal system is practiced in most Western European countries. The civil law legal system is practiced in most Western European countries, such as France. Unlike the English common law legal system, which is practiced in most former British colonies, the civil law system is one that is freely adopted by most West European countries, known as the Benelux countries, Benelux spelled as Benelux, Benelux, which are namely Belgium, the Netherlands, Italy, Spain, Portugal, and their former colonies. It has also been adopted by countries such as Tunisia. Tunisia, Egypt, the state of Louisiana in South America, and Quebec in Canada. And Quebec in Canada. Okay, let me just do a bit of explanations there. From what we discussed last week, or rather we didn't discuss, but we wrote notes. So from the notes that we wrote last week, we did talk about the different world legal systems, the different world legal systems. And basically, what we did say was that a legal system is a set of laws that is generally practiced by a particular state. It will incorporate the ways in which the law is made and also interpreted and enforced. So when you look at Zambia, there is a way that the law is made. Last time we did look at how Parliament makes laws. Even the interpretation that is given to the law, the interpretation follows a certain format. Even the way the courts are able to extend the meaning of the provisions in the law is different from other countries. And no wonder when we are faced with a situation, the first thing that we have to resort to is our own laws, the statute books, the acts of parliament, to see if that situation exists in our laws. If we don't find it in the statute books, we'll go to the case law to see if the courts have had occasion to deal with similar cases. Only after we have exhausted our domestic provisions or case law, that's when we begin to look at other countries with similar legal systems, make laws in a manner that we do. Now, There are different types of legal systems in the world. There are different types of legal systems. And one such legal system is the common law legal system. Now, the common law legal system is the laws and customs, the traditions that evolved in England. Now, you know, Zambia is a British colony. So Zambia also practices the common law system. Now, the basic features of a common law system are that it follows the doctrine of precedent. So now, what is this doctrine of precedent? The doctrine of precedent entails that if a matter is adjudicated upon by a superior court, by superior court I mean, there is a court system in Zambia. At the very bottom, we have the local court. From the local court, we go to the small claims court. From the small claims court, we go to the subordinate court. From the subordinate court, we go to the high court. From the high court, we go to the court of appeal. In the apex, now we have the constitutional court and the Supreme Court, which rank pari passu. So then, the doctrine of precedent entails that if, let's say, a superior court like the Supreme Court or the Constitutional Court determine a matter and hold it in a particular way, the rest of the courts below are bound by that decision, meaning they have to follow that decision. They cannot depart from that decision. Though the Superior Court itself has a right to depart from its earlier decision, but the inferior courts do not have that right. Similarly, if the Court of Appeal was to make a decision on a particular matter, it means the High Court, the Subordinate Court, the Small Claims Court, and the local court are bound by that decision. And the same will apply if the High Court makes a decision, the subordinate court and all those below will be bound by that decision. So basically, that's what the doctrine of judicial precedence entails. It entails that you will be bound by the decision of the superior court. Further, we see that in the common law legal system, another feature is that it practices the adversarial system. Now, what does that mean? The adversarial system basically means that where there is a dispute, you go to court and you have to prove your case. You have to go and prove your case. And if you do not prove your case properly, chances are that you will lose the case. If you are able to convince the judge or the magistrate, then you win the case. So it is about presentation of the case. understanding of the law and presentation of the case, how you put your case forward, how you lay your evidence, how coherent is what you are saying. Further, we see that in the common law system, judges are appointed from a crop of lawyers, practicing lawyers. So some of you might become judges in future. On the other hand, we just heard that in the civil law system, it is an inquisition that is carried out. So they'll just inquire, and the judges are trained. So they need not necessarily be lawyers, they'll just be trained to be judges. But for common law system, the judges are picked from lawyers. They don't need to undergo any special training. Another thing that we see in the common law system is that they practice the doctrine of equity. So the doctrine of equity simply means justice and fairness. So we see that way back, way back in England, there were these courts that were practicing the common law system. Now, you know, sometimes I think you agree with me that sometimes when you look at the law and some of its provisions, it doesn't seem to be fair. So what equity then came in to do is to bring in the fairness. Now, what does fairness entail? In simple terms, not necessarily in legal terms, but I always want to explain equity in this manner so that I hope it helps students understand. For example, you have the way you are students in the same class. One has 10 books and the other has 5 books. The requirement is that both should have 15 books. It is equitable to give the one who has 5, 10 books, and the one who has 10, only 5 books. It is not equitable only because you're distributing books and each student has to have 15 books. You give 15 books all around. That is not equity because it means the one who already had 10 will have 25. The one who had 5 will only have 20 books. So should you decide to distribute the books, an equitable distribution will entail that another person might seemingly appear as though they're being given more, and another person might appear to be given less, but at the end of the day, both will be at the same level. So when you give the other one 10 books and the other one 5 books, at the end of it all, both of them will have 15 books as required. So if you're doing a distribution, you will not just go all around and distribute 15 books to everybody, because 15 books are what is required. You will consider who has what and what more do they need and what does the other person need. Even if it entails that it appears as though the other person gets more than the other. For as long as at the end of it all, there's an equitable distribution. So that's what equity entails. So it's not about equal, because if it was an equal distribution would mean all of them the same number, regardless of what they have already. But equity will consider what one has and give them the deficit. So, as we have seen, even our laws in Section 15 of the Subordinate Court Act and Section 13 of the High Court Act, they recognize the fact that equity will be applied by the courts. But they are very categorical by stating that equity will only be applied at the discretion of the court. So we went on to look at the different maxims of equity. I will explain a few. So, for instance, equity will not suffer a wrong to be without a remedy. What that simply means is that where a person has been disadvantaged in one way or another, there should be a remedy. There should be something that can be done about their situation in order for them to seek recourse. So equity does not believe in a wrong is done and it is given a blind eye only because the circumstances are such that probably there's nothing that can be done. Equity allows the court in such circumstances to make an order so that the other person has a remedy for the wrong that they have been occasioned. Another of the maxims is that equity will not assist a volunteer. So, for instance, two people enter into a contract, they have an agreement, and then let's say this agreement is about the other person supplying particular goods to the other person. So A is supplying goods to A is supposed to supply goods to B. C comes to volunteer to help meet the quantities that A is supposed to supply to B. And B is supplied, but B fails to pay. When the matter comes up in court, only A will have the right to claim from B. C will not have the right to claim, because C only came in as a volunteer. He was not part of the contract from the very beginning. So The law will not assist you in such a situation. You have suffered a wrong, yes, but you will not be assisted. Why? Because you were not part of it. So equity will not assist a volunteer. Equity deems done that which ought to be done. I think this is straightforward. If something is supposed to be done, equity will assume that it has been done. He who comes to equity must come with clean hands. What it means is, for instance, you go and steal somebody's phone. And then that phone is also stolen from you. You cannot go to court and say, the phone I stole has been stolen by this particular person. Therefore, I want compensation. Because first of your hands were not clean in that you committed an offense. You first stole. So there's an illegality there. So if you want to come to equity, meaning if you want to present a matter to court, there should be no wrongdoing on your part. Equity follows the law. Equity, it means that equity will only be applied where the law is applicable. So if the law is not applicable, there's no remedy that you can get under the law, then you cannot run to equity to get a remedy. I guess the rest of the maxims, you can find out the meanings. These are not even exhaustive, they're more than that. Now we go on to the civil law legal system. So we see that unlike the common law system, the civil law system is that which is predominantly practiced in Europe. And it is based on codes. It is based on codes. For instance, I'm sure you've heard of the Civil Procedure Code. Now we have the Children's Code. We even have the Employment Act Code. Now, what codes do, unlike just mere statutes, codes guide you through. They tell you what to do under what circumstance. They do not just say, this is wrong, this is right, this is what. No. For them, they kind of like guide you through the process. When you look at statutes, common law statutes, ordinary statutes, they'll usually have a section that provides for offenses or wrongs. When you contravene this, you'll be sentenced to this or whatever. But with the codes, they'll just guide you. Usually they guide. They'll tell you under this circumstance, this is what is supposed to happen. So you note that the civil law system practices an inquisitorial system. What that means is that they carry out an inquiry. One need not go and prove their case, like in the adversarial system. In an inquisitorial system, an inquiry is carried out. So the judge makes a determination by finding out basically what happened and how did the wrong arise. So I've given you quite a number of examples in countries where the civil law legal system is practiced. Now we see also that the judges in the civil law system are not appointed, are not appointed from amongst the lawyers, practicing lawyers. They actually undergo specialized training. They undergo specialized training so they can be from any field for as long as they are trained and they qualify, then they are appointed as judges. So that's about it. Our next topic is Sharia or Islamic law legal system. Sharia or Islamic law legal system. Do we have questions? From what has been explained thus far, do we have questions? Yes, Mavis.
Yes, Senior Castle. I've got a question. Good evening. And in the common law, in the customary law, you said if the customary law, if you were saying the common law, the customary law fails, equity must follow. In our first topic, I don't know if I'm being mistaken with the lecture of philosophy. It was said somewhere that if the common law or customary law fails, equity must be followed. What is it a maxim or a long? Thank you.
No, you are quite correct. When the common law or customary law fails, equity must follow. Remember, what that basically means is that when you have a particular tradition, for instance, or a particular law, but that particular law doesn't seem applicable to the circumstances at hand. Because remember, the law might not envisage every situation that is going to happen. You find that there are certain things that occur that seemingly give rise to rights and obligations, and yet, by and large, by themselves, they are not provided for by the law or by tradition. So then the court can rely on the doctrine of equity to award or to compensate or to give recourse to the person that is on the losing side. An example I'll give you is this. There's a case I handled where this man was offered a piece of land by the Ministry of Lands. And he went on and constructed a house and constructed three flats. and a chicken run and so on and so forth. It was quite a big piece of land. Years down the line, somebody comes up and says, this is my property. And they have an earlier title. Now, the law in itself states that a person with earlier title is taken to be the owner of the land. Anyone that is given subsequent to that title, then they are illegally there. And ideally, the property just goes. It doesn't matter. You don't even get compensation for the structures you put there. Can still allow the judge to make sure that probably the same Ministry of Lands then compensates. Now you see this, but compensated. So the law does not provide for compensation. It means you lose out. All those structures, the flats, the house, that person loses out. But a judge can apply the principles of equity and order the ministry to compensate, because it is the ministry that took that somebody else. So what landowners are allowing squatters or whatever they are called to go on and build on their land. So if I have a plot and I don't have money and somebody has recently gone on to begin constructing, I let them do so. After they're done, Eddie just became a landowner of about 48 houses. She became a landowner of 48 houses because on a property, on a piece of land, some squatters went and built. Different individuals, 40 something, 48 or so, went and constructed on her property. And the court said, no, this is a piece of land. And ordered, can imagine somebody who never sweated, suddenly they're homeowners. They own a fleet of so in houses. In such a situation, the prudent thing to do, if I was a judge, is to apply the principles of equity and say, okay, yes, you cannot demolish for this person because this is their Pindola City Council, should compensate all those people that had constructed there because they were given plots by the council. They just did not go there and begin constructing. They were given by the council. Example of the situation